Good evening. Good evening. Can I have your attention? Please be seated. Good evening. Good evening. This meeting will come to order. This is the April 2018 Zoning Board of Appeals. There was no March 2018 meeting this year. Please stand for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Roll call, please.
Mr. Casey has advised that he will not attend tonight. Mr. Tezzola?
Here.
Ms. Ferrante?
Here.
Mr. Soda?
Here.
Mr. Vecino?
Here.
Ms. Valakut? Here. Mr. Dubois?
Here.
Mr. Hirsch?
Here.
Thank you.
Thank you. Also present, Meg Green, our recording secretary. Stephen Harris, our zoning officer. Tonight we'd like to welcome Christine Valakut as a member on this board. She's been newly appointed, so we welcome her aboard. If there anyone here feels that there's a board member that might be a conflict of interest to their application or hearing, please let us know. Okay, so that will be it, Mr. Secretary.
Item number 1, 40 Crabtree Lane, MBP 12/62/2 in an R7.5 zone. Robert Farrakos, applicant, represented by Danielle Berkery, Esquire. RMF Builders, LLC, owner. Appeal of zoning permit dated 10/24/2017.
Okay, just before we get started with this hearing, this hearing had been held open for the last 2 hearings. Board members, let's see, who was on the hearing for this? John? Gary, were you on? Okay. You weren't, Bill, weren't you part of this hearing? No, he wasn't, so let's see. 1, 2, 3, okay. Okay. Gary, you have to sit in for Christine Valakut on this one here because she's new. She hasn't been part of the hearing for the last 2 months, so it's only fair to all that. Did you do 1 month and he did 1 month?
That might be the case.
Were you here for both?
Yeah,
you were here for both
I
hearings?
was here for the last one.
Okay. Okay. So we'll use you. Okay. All right. Thank you. Okay. Ms. Berkery?
Good evening, folks. Attorney Danielle Berkery from Brenner, Salzman, and Wallman in New Haven on behalf of Robert Farrakos. Thank you again, folks. I know we've done this a couple of times, and then we missed a couple of meetings. Just for the record, I just want to make sure that we do have there'll be 5 voting members.
We absolutely do. That's why I checked.
Just because
these are all people that are familiar with the last 2
okay,
hearings.
I'm aware that we have to close the hearing on this tonight, but obviously the board has some time to deliberate on it. And as you folks probably are well aware, in order to overturn a decision of the zoning enforcement officer, it requires a 4 out of 5 vote supermajority. The last time we met, I believe Commissioner Soda had directed a question to the city attorney talking about how there could be a lot consolidation, lot line adjustment, and approval of this lot given the 2001 merger decision by the Zoning Board of Appeals. The city attorney had submitted a written memorandum echoing what I believe Zoning Enforcement Officer Harris said, basically that this decision should have been appealed to Superior Court under 8-8 and that the issue wasn't properly before the board and there really wasn't any opinion about the underlying decision that the ZBA had asked. And so I thought where we had left it the last time was that the city attorney was going to be present tonight in order to discuss either the underlying decision or any questions that the ZBA members had about that. But one of the things that I did do for tonight, I just wanted to put into writing some of the sort of case law and the standard of review that I read into the record last time. I understand that the ZBA doesn't often hear appeals of zoning permits, appeals from Stephen's decision, and so what the standard of review is and what your role is on an appeal like this, might not be as clear to you as it is on other things that you hear more normally. So what I did was just a quick letter, also attaching a case called Caserta versus the Zoning Board of Appeals of Milford, which is somewhat the seminal case on how Zoning Board of Appeals review decisions of the zoning enforcement officer when appeals are taken under 8-7. And I understand I just gave this to the board tonight, so I'll just quickly review the letter, read it into the record. As I stated, our appeal was brought under 8-7, which gives the ZBA the statutory authority to reverse or affirm wholly or partly, or may modify any order, requirement, or decision as, in its opinion, should be made in the premises, and shall have all the powers of the officer from whom the appeal has been taken. And in your decision, you should state on the record the reason for your decision. In this Caserta case, the Connecticut Supreme Court explained the ZBA's responsibility in reviewing appeals of a zoning enforcement officer's decision. It is the board's responsibility, pursuant to the statutorily required hearing, to find facts and to apply the pertinent zoning regulations to those facts. In doing so, the board is endowed with liberal discretion. The ZBA must give a full hearing on such appeals, and at the hearing, no one may be deprived of the right to produce relevant evidence or to cross-examine witnesses produced by his adversary, or be fairly apprised of the facts upon which the board is asked to act. I'm sure that we can all agree we've had a full hearing on this with plenty of evidence and testimony. As a result of these statutory obligations, the Connecticut Supreme Court concluded it would be inconsistent with these broad grants of power to the board and with the concomitant procedural limitations thereon to envision the board's function as anything less than a de novo determination of the issue before it, unfettered by deference to the decision of the zoning enforcement officer. On appeal to Superior Court, the court will not look at the decision of the ZEO, but will look at the decision of the ZBA. We therefore encourage this board to give this matter the fresh look that the statutes allow for, to hear the testimony of the neighbors and to review the evidence presented regarding this decision. I guess that's somewhat of a long-winded legal way to say, just because Stephen made the decision that he made, and he has stated on the record that given the map in front of him, he really had no choice. He had to issue the zoning permit. Just because Stephen had to do that doesn't mean this board has to do that. And in fact, the board has more responsibility. You are supposed to give us a hearing. You're supposed to look at the evidence. You're supposed to pull the rug back and look at how this decision was made. So with all due respect to Stephen, and I work with him regularly, I don't want this board to feel that just because he made the decision that he made, that the board can't overrule the decision and look at this evidence in a different light. Certainly evidence that wasn't presented to him at the time he was making the decision. Another thing that the city attorney had said, and Stephen has also said, is that this decision should have been appealed to the Superior Court. As this board is well aware also, there are specific statutory provisions that allow aggrieved persons to appeal decisions of certain commissions to Superior Court. I don't think this is one of those decisions. So in the letter, I say, additionally, reliance on Connecticut General Statute Section 8-8 as the proper mode of appeal is also misplaced. The right to appeal a zoning decision is limited by statute. Connecticut General Statute 8-8B permits, quote, any person aggrieved by any decision of a board may take an appeal to the Superior Court for the judicial district in which the municipality is located. The term board is defined under the statute. So if you look at 8-8, subsection A, subsection 2, it's defined as a municipal zoning commission, a planning commission, combined planning and zoning commission, a zoning board of appeals, or other board or commission, the decision of which may be appealed pursuant to this section, or the chief elected official of a municipality, or such official's designee in a hearing held pursuant to 22A250, which does not apply in this case. I think the record before you folks is clear that this was not a decision of the Planning and Zoning Commission. This was a decision of the chairman of the Planning and Zoning Commission. It was done administratively. It was not done after a hearing. It was not on an agenda. It was merely part of the chairman's report. And sort of to the same effect, it was not something that the board would publish. It was published by the applicant, but it wasn't published by the board. And so I think there's been somewhat of a desire to say, well, this isn't properly before you folks. So don't pull that rug back. Let's not look at what we're talking about here and how this zoning permit came to be, because they should have gone to Superior Court. I actually think there's a good chance if we did appeal that to Superior Court, we could have gotten kicked out of Superior Court, because there's no statutory authority to appeal a decision, an administrative decision by the chairman of the Planning and Zoning Board to Superior Court. I've certainly looked for that authority, but I have not found it. So simply because an appeal was not taken under 8-8 doesn't mean that this court cannot review the underlying decision of why the zoning permit was granted. And I would just sort of summarize for you folks that the record before you, I mean, the applicant has submitted written materials stating that this decision was properly done. But you have written submissions from me, you have testimony from the neighbors, you have your own board's decision from 2001, which has testimony from the zoning enforcement officer at the time as to what could be done with these lots. And then when asked directly about how these lots that were merged could then be the subject of this application, there's nothing from the city attorney. There's nothing from the zoning enforcement officer. So I think the record before you is pretty strong that this decision was wrong. I think the question that you have to ask yourselves is whether or not you're in a position to overturn it. And I believe, given the case law, given your statutory authority, your statutory responsibility, I think that you can. Happy to answer any questions.
Any questions? Go ahead, Mr. Soto.
Attorney Berkery, do you know what date the lot line adjustment was made?
That decision, it was in 2016. I'm sure I've submitted it. I'm sure Kevin has submitted it too with the exact date.
It looks like it might have been
April of
26th.
2016? Correct. Thank you.
2/15.
Yep, 2/16?
2016?
2016?
2/15 or 2/16? What do you have? 2016.
It's 2016, yes. Yep.
What was the date, the month and day?
I'm sorry, what was
The
that?
month and day.
April 26th.
April
2016.
26, 2016?
Mr. Casaden has it right there for you.
Because in the New Haven Register says it was done on April 19th. April 19th.
That might be the
Says-
case that the decision was, and then it was published. It
It
looks
says
like
approved by the planning and zoning, approved by the chairman of the City Planning and Zoning Board on April 19th, 2016.
That's correct, and you are correct, and then the publication date was the 26th.
Well, and then I'm looking at this other stuff that turned in on Exhibit I, and he says here that under the regulations that it has to be reported at the next regular meeting, which would have been the 19th that same day, and it wasn't reported until the 3rd, the May 3rd meeting. So I don't know if that helps or not. it wasn't reported at the next meeting, which was the 19th. It was reported on May 3rd, which is
So-
after the 15-day period.
Right, so the publication was done before, your point is that it was published before it was even on an agenda, even before the board.
Well, on this Exhibit I that he gave us, it says that the chairman has to report it to the board on the next, must be placed, where does it say? The chair shall report each action at the next regular public meeting of the board, which would have been that same day, and they waited 2 more weeks to do it.
You're correct, because we have the May 3rd agenda.
Right.
Where the
Exactly.
chairman's
The May 3rd
report is
agenda
on.
says that's when he reported it.
That's correct. So then they're, sort of adding to the confusion of whether or not this could be appealed.
Well, it's already past the 15 days when the
Correct.
chairman reported it to the chairman, to the zoning board.
Well, I'm not sure that it was past the 15 days, because if it was published on April 26th, the 15...
Well, the zoning meetings are every 2 weeks, right?
Yep, no, you're correct, that it was not on the agenda
Right.
until after it had been published, which is a good point, and sort of adds to the confusing question of, could it be appealed, when could it be appealed, and how would anybody know about this thing? One of the things, and I didn't submit this, but I'm happy to do so, my client who had looked at some of the old meetings from the ZBA found some, back from 2009, at the time, ZEO Linda Stock talking about, there was a question on, I believe, a variance, but they were talking about lot line adjustments, and she said, the question from the ZBA was, why couldn't we do a lot line adjustment? And she said, well, you can't do that unless you're creating, you've still got 2 conforming lots. That's not what we had in this case either. We had 2 non-conforming lots, and then when the lots were even merged together, I believe there's still a non-conformity. So it's, I'm not saying that this isn't a procedure in the regulations. I think it was inappropriate in this case. And I think to go back to the point of who could appeal this and when could we appeal this, we've appealed the zoning permit. There's been a decision, and we've appealed that decision to you folks.
So refresh my memory, in 2001, this board said it wasn't a lot anymore?
In 2001, Peter Crabtree had 642, so said, pre-existing non-conforming lots, nothing's been built on these old lots that existed on an old subdivision, and it conformed to the regulations back then, so we're gonna, stamp these lots now, even though they don't conform. But then at the time, the neighbors testified, wait, these lots have actually been used as part of a bigger lot. And so Peter Crabtree, in what I think is pretty interesting, actually went to the board and said, overturn my decision is wrong. These lots, there was a shed, there was a barbecue, there was a garden. These lots have merged with another lot, so they can't be 642'd anymore. They're not these pre-existing non-conforming lots anymore. They've lost their legal identity, and if they want to do something with them, they'll have to come for a variance. But I was wrong, and in light of the evidence, these lots have merged.
Okay, we all set? Mr. Soto, we all set? Okay. Any other questions for Attorney Berkery? Anyone else speaking on this appeal? Come forward, sir.
Good evening. My name is Gerald Sheehan. I live at 46 Crabtree Lane, and I was involved in 2001 doing a lot of the research on that lot, put a lot of effort and time into it. The whole neighborhood put hard-earned money into it. And in the end of that appeal, Peter Crabtree, who was a straight by-the-books guy, said I was wrong. He actually called the Wrights home, and Mrs. Wright answered the phone, and she happened to say he was talking about the case, and she said, oh yes, when we sold that house, I told my husband we should get insurance on that lot because of the shed, if kids are playing on it, we could be liable. So she knew there was a shed, he knew there was a shed, yet they contended nothing had ever been done with that lot. And about 5 years ago, my wife and I were considering moving or upgrading the house. We loved the neighborhood so much, we put $25,000 into our house. And now somebody just comes in the back corner and erases a line and decides it's a building lot, which the city had ruled it is not a building lot anymore. That's all I have to say on the matter.
Okay, thank you.
Thank you.
Is there anyone else speaking? If you're already on record from one of the hearings, you can speak briefly, but we don't want to be repetitious on
A
this.
little bit different. My name is Robert Farakis. I'm at 35 Deerwood Avenue, Milford. Just to give you just a quick history of Crabtree Lane. 40 Crabtree Lane consists of two 25 by 100-foot lots for a total of 50 by 100, and it's also referred to as lots 132 and 133. It's in an R75 zone, non-conforming. June of 2001, ZBA ruled that these merged lot 133 was merged to 27 Deerwood Avenue due to a structure on the building, which we proved to the board. In 2016, a lot line adjustment is made and presented to the zoning department, and it becomes a building lot. The question before the board and the city attorney is, how can you make a lot line adjustment to a lot that doesn't exist? The lot is merged to 27 Deerwood. Also, in 2009, Linda Stock stated in the minutes, and it was item 4, that lot line adjustments must start with a conforming lot and end with a conforming lot. These are non-conforming lots. So how does it happen? So there's a mistake somewhere here. We hope that you can overturn this decision. Thanks.
Okay, anyone else? Anyone else? Okay.
Mr. Chairman,
Yeah,
Mr. Chairman, may I respond? 'Cause it's,
Oh, yes, I was going to just ask you,
appealing
Mr.
my
Harris.
order.
So you would be up next.
Stephen Harris, zoning enforcement officer. The issue in this case is pretty simple. Was a zoning permit issued for a lot of record? That's your only question that you have to answer. And the answer to that is yes. In 2016, a lot was created. Whether members of the audience or members of the board think that perhaps it wasn't proper, maybe, or whatever the reason they may think. A lot was created. The decision it was signed off by the chairman of the Planning and Zoning Board. That was advertised in the newspaper. The statutory appeal time ran out without an appeal being taken. Therefore, it's a lot of record, whether anybody likes it or not. So, is there a lot of record? Yes. Was a zoning permit issued for a lot of record? Yes. I have a legal responsibility to issue the zoning permits for lots of record. And that's the only thing for the board to consider. Everything else is a distraction.
Okay, thank you. Mr. Crusade?
Good evening, Mr. Chairman, members of the board. For the record, my name is Kevin Crusaden with Carroll Crusaden & Moore at 3 Lafayette Street here in Milford. I will keep it simple and brief. I know you've had a lot of discussion on this. I just want to make sure that everyone has my February 13th, 2018 property owner's reply to Attorney Bercury's previous comments and letter. If you don't, I have some extra copies with the exhibits. I think Mr. Soto was referencing it when he had the earlier question about the minutes, but if you don't, I can approach and give you some copies. Attorney Bercury has a copy as well. Do you need you have that copy?
Do we all have copies? We do.
So I don't expect, it's only 2 pages. I don't expect you to read it as we're talking. I was hopefully between the last 2 months, because this has gone on for 4 months, you've had time to read it and digest it. But
I think most of us have briefly
Okay.
looked through it.
So I don't disagree with Attorney Bercury that they have a right to appeal Stephen's decision. Where the disagreement arises is the underlying reason for the appeal. So for example, Stephen Harris issues a zoning permit and it's not a lot of record, okay? In that situation, this board would have the authority to make a decision on it. In the situation that's before us tonight, the Planning and Zoning Chair by authority granted to him by the Planning and Zoning Board under their subdivision regulations and their zoning regulations, made a determination with a big package of information, by the way. This was not something, this hasn't been said, but it could be inferred from the comments and also from the reactions of the board that something sneaky went on. You can't get anything through Stephen Harris or David Sulkus below board. Everything is above board 120%. I don't disagree with them all the time, but I don't agree with them all the time on the decisions they make with that, but I can tell you that in this particular circumstance, every single regulation was followed to, including publication of notice, which we were not required to do, but we did anyway. I got a little bit off track there, but I just wanted to address that. So in this case, the P&Z chair makes a decision based on the evidence, fully aware of what the history of these two lots were because there was extensive information presented, which you also have in your packages. The Zoning Board of Appeals, under state statute and under the Milford zoning regulations, does not have the ability to hear an appeal or decide an appeal on a non-zoning enforcement action. So you can hear an appeal of a zoning enforcement officer issuing a zoning permit. That's completely legal, and I agree. They have a right to appeal that. They appealed that within the period of time. Where the disconnect is and where we disagree and where their claim has to fail legally is the fact that they're not citing any other reason other than this building lot of record from 2 years ago where the time has passed and was an action by the Planning and Zoning Board through their chair. The fact of whether it was the chair of the Planning and Zoning Board is irrelevant. It's the fact that it wasn't done by a zoning enforcement officer acting in their zoning enforcement capacity. That's the critical issue. All these cases that Attorney Berkery has provided to you say the same thing. And so her position is, well, it says you can't hear a decision of a Planning and Zoning Board. It says that, but it also says you can't hear any decision unless it's a zoning enforcement officer in a zoning enforcement action like a zoning permit. That's the law. And I understand Stephen's been concrete about this, and he's very direct, and it's bristling to people that he says, you know, that's irrelevant, let's not talk about it, about the underlying lot approval. I understand people want answers on that. You go down a slippery slope when we start talking about stuff that was approved a couple of years ago and how did that happen, and if the board didn't have the authority to hear it anyway, we don't want to talk about it. I've been here at the first meeting, I was here at the second meeting. I offered at the first meeting to describe how those lots came to be, or that lot came to be. Here again tonight, it's provided in the memo. It wasn't one lot, it was 2 lots on the subdivision map originally. Only one of those lots, lot 133, had been merged with the adjoining parcel, not 132. The evidence in the record is that the shed was on lot 133. So when we're thinking of a lot, we're not thinking of 40 Crabtree Lane as it exists today. Originally, surprisingly, that old subdivision map, that was 2 separate lots of whatever they were, 20 feet wide or 25 feet wide each. So under the City of Milford regulations, 6.3.4, I think, which is non-conforming lots, and it's right after the merger section that we're talking about.
That would be
6.4.3, excuse me. Notwithstanding the provisions of 641 and 642, 642 being the merger provision, vacant non-conforming lots may be combined to reduce any nonconformity with respect to lot size in accordance with section 2.3.1 of the subdivision regulations. So it says, irregardless of this previous regulation on merger, you can do this. And so 2.3.1 of the subdivision regulations gives the chair the authority to sign off on a lot line adjustment. So that's how this lot came to be after the fact. And if we were going to talk about I can answer a question if you want to ask it.
You have a question right now, or do you want to wait for him to finish
Yeah,
his presentation?
no, while you hit that.
Okay.
You're saying there were 2 lots, so there was one with the shed,
Yes.
one without the shed.
Correct.
And you moved the line closer to the shed to create the other one into a building lot. Is that what you're saying?
What we did is we adjusted the lot line from the lot that did not have the shed originally on it. There was no evidence in the record.
So that
there was-
became the approved building lot?
That's correct. And then
So-
that lot line was adjusted.
Okay, I see what you did now, okay. I thought the lot with the shed became the building lot. You moved the line closer to the shed to create a legal building lot.
Right.
I know what you did now, okay.
And there's a reason, and I get into it in my letter, and I don't want to belabor the point, but there's a reason that there's cutoff times and statute of limitations for appeals so that people understand what their property rights are, purchasers of property understand what their property rights are and what they're able to do on the lot, which goes to my point that my client, Mike Field from RMF Builders, paid fair market value for this lot as a building lot. He's been carrying it now for 4 months with the taxes and so on and so forth, but he bought that because it was a certified building lot and any appeal period had expired. So you can't bootstrap in, and you don't have a right to go back and look at that earlier decision. You could look at Stephen's decision all day long. Did Stephen make the right decision? Does this lot have the proper setbacks and so on and so forth? But you can't decide whether it's a building lot. And I don't like, it's not comfortable for me to sit here and tell you you can't do that, but legally, that's where the argument, that's where it stops.
Well, now I see what you did, because you basically just took that lot line, moved it closer to the shed. That piece of that lot stayed the way it was, and you created a new lot on the other side of it.
That was the, I don't know if I
We're
can.
not going to have any yelling out, please.
That was the position that I took. I vetted this with David and Stephen with much research prior to even filing this or wasting anybody's time or money or the rights money who were the previous owners of the property. That's how that was accomplished. That's how it was done. It followed every single regulation. There was no notice requirements. So to my point
So
of...
where's the piece of property now that had the shed on it? That's on the adjoining piece from
No,
aside?
that lot that had the shed on it, it was lot 133. That lot 133 and lot 132 are now 40 Crabtree Lane. So the 133 lot that was merged, supposedly, with 27 Deerfield, that lot no longer exists. What happened was lot 132, which was an original subdivision lot, that lot line was moved over on that, so that same piece of parcel. So it's set at two 25-foot wide lots. There's a 50-foot lot. Because, for example, the 132, which is a 25-foot wide lot on an old subdivision map, somebody could have came in and got a building permit for that lot on its own. But the discussion was, let's move the lot line over so it's a more conforming or less non-conforming lot and move that lot line over to encompass what was 133.
So basically, you had two 25-foot lots.
Correct.
You moved the line all the way over 25 feet
Yes,
and created one lot.
yes.
But that 25 feet is the lot that was merged in 2001 that they're talking about?
133, yes.
Okay.
Okay, any other questions for Mr. Crusaden? Okay,
Thank you.
okay, one more time. Any other comments?
I'm sorry, I do know the board has other matters to consider tonight, but it's somewhat unfair to say, well, you can't take a look at this decision, yet this decision was done properly, and this is how it was done. The decision back in 2001, and this is from Peter Crabtree, that the lots had merged. There was other evidence. There was discussion of a shed, but there was discussion about a barbecue, a garden, and other things like that. And so his conclusion in his May 11th, 2001 memorandum was lots 132 and 133 couldn't be considered as candidates for certification as individual lots. And under these circumstances, to initiate construction will require a variance of lot area from 7,500 square feet to 5,000 square feet. So, there was a decision back in 2001 that the lots had merged. So then the owners of the property, they seemed to get a second bite at the apple. And oh no, it was only 133 that merged, not 132. And then that gets done administratively. Nobody knows about it. There's publication before it even is on the agenda for the board, and now ZBA, you can't look at this decision, you have no legal authority. But that's not correct. Back in 2001, the decision was, and there was evidence, that the lots had merged. And so we are attacking that underlying decision because as evidence and testimony supports, they said this isn't a building lot. You know, it's not two building lots, that the lots had merged. And again, I didn't hear anything from Attorney Kersaden or from Steve Harris saying that that decision from the chairman of the Planning and Zoning Board could in fact have been appealed to Superior Court. I certainly spent the time doing the legal research myself, and I didn't find anything. The statute is construed narrowly. It wasn't a decision of the Planning and Zoning Board. It couldn't have been brought to Superior Court. And so we are not in a situation where, oh, we should have appealed, 2 years ago, and now we're here before you. We're appealing the zoning permit. And as I set forth in the memorandum I gave you, just because Stephen had to issue the zoning permit doesn't mean that after a full hearing, if you think it was wrongly issued, that you can't overturn that decision.
Okay, thank you. Okay, this hearing's closed. Okay, so we've heard enough on this, so I don't think you're ready to make a decision on it. Now that the hearing is closed, we still have, believe it or not, 65 days to still vote on this. So if we're ready for a decision right now, we can do that, or we can certainly put it off. It's up to you guys.
I think we got to get going tonight. I think we should just put it off. Vote on it next month when we have a lighter agenda.
You want to make a motion to that effect?
I make a motion, we postpone the decision until next month.
And that gives you more time to look into any of this other stuff that's been brought up, or?
We get to read all this information. There's a lot of information here.
Okay, do we have a second to?
Second.
Okay. Okay, all in favor? Mr. Dubois?
In favor, yes.
Ms. Ferranti?
With the motion.
Mr. Vecino's with the motion.
Mr. Soda?
With the motion.
I'm with the motion, okay. So we have a little bit more time on this.
Mr. Chairman,
Mr.
the people involved in One Seaview are out in the hall trying to work a deal, trying to come reach some sort of solution, so they've asked you to skip over them for the time being.
Oh, so we might have it, but we're just going to pass over it.
We may not.
Okay.
But for the
Okay.
time being, we can move on to surf.
Okay. Can I ask someone at the back of the, can you please close the door on your way out, please? Thank you. Okay, so we're going to move up to item number 3, 80 Surf Avenue. Go ahead. Yep.
Item number 3, 80 Surf Avenue, MBP 27/472A/42 in an R10 zone. Skinner Enterprises Incorporated, applicant represented by attorney Kevin Kersaden, JJV LLC owner, variance of section 3.1.4.1, front yard setback to 6.3, where 25 is required. Section 4.1.1.4, deck projection to 6.3, where 21 is permitted. Eave projection to 5 feet, where 21 is permitted. All to build a new single-family dwelling.
Good evening, Mr. Chairman, members of the board. Kevin Kersaden. My office is at 3 Lafayette Street here in Milford. I'm here tonight on behalf of Skinner Enterprises for this lot on 80 Surf Avenue. This lot is actually combined from 3 smaller lots from an early 1900s subdivision map. It has 2 front yards, and you can see, if you have the set of plans there, or if you can look here, the neighborhood, the way the houses are facing on the street, are slightly jogged at an angle. They're not square with the street. So Mr. Skinner, who's here tonight, decided that in order to make the houses look uniform for the street, he angled the house a little bit so that as you're driving to the eye, it looks even and straight with the street, but that's what's causing the house to go back at an angle from the front of the lot to the back of the lot. Like I said, it has 2 front yards. The side, it's not the side front yard, but I'll say the second front yard is Willow Street, and that is a paper street, paper road. So there's no, it's not paved there, it's just grass. If you were to drive by, you'd think it's just part of somebody's yard. There's wetlands in the back, and the city, which impacts where you can build to a certain extent. And it also has the city owns a piece of property in the back. It was, I don't know, it was deeded to the city in some tax situation years ago. So the request is for these variances in order to construct a single-family home. With the 2 front yard setbacks, the house would be 9 feet wide if it wasn't granted a variance because of the extent of the setbacks required. So there's no, and under the previous lots that existed, they were just too small, and you couldn't build a house on any of those lots. It's another one of those old subdivision maps. So it's reducing the non-conforming lots and asking for a minimal variance. Years ago, when you brought variances, you would ask for, the setback from the foundation or from the side of the house. And over the past few years, or maybe even more, it's developed into where once you ask for that, you also ask for the overhangs. So that's where the eave projection setbacks come in. And then it just kind of doubles and triples the amount of variances that you're requesting. But so the main variance is for the house, because without it, you wouldn't be able to construct a house on the property. And the hardship is the 2 front yards and the width of the lot.
Questions for Attorney Crusaden? And the house is positioned that way on the lot because of, it's following suit with the house next to it, to the left.
The adjoining, yeah, the houses on the street are all kind of angled. Maybe it was the way the street was developed over the years, but it's to line up and look straight with the street, with the other houses on the street as you drive down the street. That's the reason for it being angled back and why it kind of intrudes into that side yard a little bit more than being straight on. Because if it was constructed the other way, the house would be angled, it wouldn't look right from the street. So that's another hardship for the angle of the house on the lot.
Okay, but still by the size of this house, it's still there's plenty of usable property on it to put that house there.
Well, not without the. It's not a side yard setback we're asking for. It's 2 front yard setbacks. So you'd only be able to build a 9-foot or a 10-foot wide house. And then you have wetlands restrictions in the back. So you wouldn't, if it was side yard setback, I would agree with you. Yeah, but those are actually 2 front yard setbacks.
Okay, any other questions? No? Anyone else speaking in favor of this application? No one else in favor? Anyone here opposed? Opposed to this application? Any questions? Okay, this hearing's closed. Okay, your thoughts? I guess the hardship is with the land there.
Well, I went by it. You got the paper street, which is all grass, so you got plenty of land there. There's plenty of room for a house there, so I don't have a problem with it.
Yeah, I think the compelling item is the 2 front yard setbacks that they need to comply with, and I do think that's a hardship.
Okay, we need a motion.
Make a motion to approve.
Second?
Approval is based on the hardship of the corner lot with the 2 front yards.
Okay, we have a motion to approve, and I have to just take a step back here right now. Ms. Valpet, you will be voting on this. Okay, I should have, the actual board will be voting on this right now with Ms.
Mr.
Valpet.
Chairman, was she seated prior to the beginning of this hearing, of this item?
I neglected to do that,
And she can't vote.
so who would have the 5th vote?
I believe it's
Mr.
still
Dubois?
Gary.
Okay, all right, okay. I'm sorry. I didn't seat you. Next hearing. Okay. All right, so things are just the way they were from the beginning. All right, so we have a motion to approve, and we have a second on the motion. Mr. Dubois,
With the motion.
Ms. Ferranti,
With the motion.
Mr. Facino,
With the motion.
Mr. Soto,
With the motion.
I'm with the motion. Okay, before we proceed,
I have an update on Seaview. The parties are very close to an agreement, and they have asked that you postpone opening that item until May 8th.
okay, before we go any further, Ms. Valaquit is seated, okay?
You should also, Mr. Chairman, you should also say for the record that 1A Seaview Avenue is being postponed until May 8th.
All right, item number 2, 1A Seaview Avenue, will be postponed until May 8th. Moving forward, item number 4.
Item number 4, 107 Melba Street, MBP 29/587/36 in an R5 zone. Kevin Crusaden Esquire, applicant for Craig Southard and Jerry Southard, owners. All requests listed below are to construct a new single-family dwelling. Vary section 3.1.4, west side yard of 4.6 where 10 feet required. East side yard of 3.8 where 5 feet required. Lot coverage of 79.9% where 65% is permitted. Vary section 4.1.4, west eave projection to 3.6 feet where 8 feet is permitted. East eave projection to 2.8 feet where 4 feet is permitted. East front deck projection to 3.8 feet where 4 feet is permitted. West front deck projection to 4.6 feet where 8 feet is permitted. East rear deck projection to 3.8 feet where 4 feet is permitted.
Good evening, Mr. Chairman, members of the board. Kevin Crusaden, my office is at 3 Lafayette Street here in Milford. I'm here on behalf of the Southards who are here in the audience tonight. Jim Deno, who was previously here, I believe this application or the previous application was heard by this board in January and was denied. There's been some revisions since then. Jim Deno was unable to make it tonight. But I wanted to point out, I had several discussions with Jim, and he was going to try to come back, I think, a little bit earlier, but he made quite a few attempts at making revisions to the plans. When they were here in January, there was some concerns by the board about the number of variances being requested. There was no, I think in the board's opinion, there was no hardship that was articulated or identified. And Jim and I had talked about it, and the Southards had conversations with Jim, and they heard your concerns, and based on that, came back with a new application with a redesign. One of the more important items is, and I think the house was pulled back from the water side. This is a waterfront property on Melba Street. But there was a deck, not a front deck, it was a waterside deck. That deck's been removed. The house is being pulled back 10 feet from where the existing house is. These are all side yard setback, and then the eave projections that go along with those side yard setbacks. The plan would be that the existing house would be destroyed, or demolished, or raised, and then a new house would be built that's in compliance with FEMA regulations. Right now, the house that's existing is not FEMA compliant. The existing house, if you've been down there, a lot of those houses, especially the older ones, are right on the edge of that seawall. This would be pulled 10 feet back. No deck there any longer. Additional changes that were made, that the roof overhangs on the previous application were 24 inches or 2 feet. That's kind of consistent with Mr. Deno's designs. If you've seen some of the other properties he's built, it's now down to 14 inches. So he took 10 inches off of the roof overhangs to reduce the requested setback. It's a much smaller roof deck that he's proposed. The it's important to note that the house is staying as far as the side yard setbacks, it's staying in the same footprint, being pulled back, but the house is also about 10 feet longer than the existing house. So, like many of these old lots, if you did not grant the side yard variances requested, I think this house would be, I want to say 15 feet wide. So it's another situation where you have a narrow house. The hardship being that the lot is 25 feet wide, which is half the required width in that zone. It's 158 feet plus or minus long, which is over twice as long as the required length of 70 feet. It crosses the VE 13 and AE 11 flood zones, requiring the structure to be elevated. As the board knows, existing nonconformities that are being reduced or eliminated as a result of new construction can be considered grounds for granting a variance when no hardship's present, but there is also hardships here. Very important to note that the lot coverage is being reduced from currently 99% to 79.9%. So although we have to ask for a variance because 79% is over the 65% allowed, they're actually reducing the existing coverage from 99%. So it's a variance that we're asking for, but we're also bringing it closer to what the conforming regulation is. And the new structure is going to be 100% FEMA and current building code compliant, which is important on the waterfront and in the flood zones. Those are important reductions in nonconformities, and those are, once again, independent grounds to grant a variance the courts have held. So when you look at this, once again, it looks like a significant amount of variances, but the projection variances under section 4.1.4 really stem from the fact that those are the overhangs and the decks as far as the side yard goes. And they're as a result of it being entirely new construction. This is a pre-existing non-conforming lot. It's undersized for the R5 zone. It's 3,996 square feet, where 5,000 square feet required. So not only is it long and narrow, it's also smaller than what's required, crossing the two flood zones that I talked about. So actually, I did the calculation, and if the setback variances were not granted, the house would be 10 feet wide. There's been a lot of other homes built up in that area since the storms that have taken place over the past 5 to 7 years. Some of them have gotten variances, some of them have not. I understand that each lot stands on its own when it comes before the board. However, it's not out of character to grant a variance for a house like this on a lot like this. And subject to your questions, that's...
Okay, my question to you is what's the house size now? Because you said, you know, without the variances, the house would only be 9 feet wide.
Yeah.
I believe they can probably build on the same footprint right now without any of the variances.
Well, they could take the house down and build on the same footprint and elevate it. But in this case, they're moving it away from the water, which would trigger the same setback variances that we're asking for tonight. So the existing square footage is a little over 1,600 square feet, and the proposed square footage is about 3,500 square feet because they're adding a third or a half a story on the third. So it's 2.5 stories versus 2 stories.
You know, the real issue with what you're presenting, even like right now to us, and it happens many times, is it's almost like the lot is what it is, and we're always trying to put more on that lot than should really be there. And one of your arguments was we were at 99%, which was entirely, you know, unrealistic, and to say it's been brought back to 79%, 79.9, where 65 is permitted.
Yeah.
To me, that's not really a good argument as far as a hardship.
Why is that? Why is that not a good argument?
Well, I think it was a little bit asking too much to be up to 99% from 65.
Well, no,
to say you cut it back
yeah, well,
to 79.9.
Well, because these lots, a lot of those lots, especially in this block of that neighborhood, have, they're almost all concrete, they're almost all slab, so a lot of that slab's being removed. So it is going from 99% down to 79%. And that is a reduction in an existing nonconforming. It's going in the right direction, even though we have to ask for variance for it because it's still over the 65%. It's not asking for something exceeding what they have now, or but it is still exceeding the regulations.
Okay, thank you. Mr. Soto?
Attorney Crusade, you said the existing one was 99%
The existing coverage,
coverage. That included the concrete?
yes.
Okay. And this one is 79?
The proposed is 79%.
Is 79. What was the original footprint, square footage of the house, the existing house? 1,600?
Well, the original square footage, which is 2 stories, was a little over 1,600.
Okay. And what was the width of that house?
It's the same width as being
So
proposed.
it's the same width, you just
Right.
made it,
It's pulled back and made longer,
how
correct?
much longer, 10 feet, did you say?
About 10 feet longer than what's existing now. So it's coming closer to Melba Street. So as part of these applications, which you see a lot of, you have the additional cost of elevating the structure. Did you have another question? I'm sorry.
Right. No, I just was going to say, that, 16 feet is a very narrow house, very narrow.
Any other questions for Mr. Casaden? Anyone else speaking in favor? Please come forward if you're speaking in favor.
Good evening, members of the board. My name is Craig Southard. I'm the owner of the 107 Melba Street property with my wife. Thank you very much for taking the time to hear us again. Don't know if you remember, we were here in January and you gave us some good advice to go back, look at the design, see what we can change so that we didn't have so many variances. We went back and we did as much as we felt we could possibly do. We pulled the deck off the front. We'd love to have a deck there, but we pulled it off. We removed the stairs from the side. We changed the layout of the roof so the variances on the side, and I'm not technical on this, but the overhang variances weren't as large. When we look at it now, the only possible thing we could do to reduce the variances any further would be to shrink it in width. And honestly, it would just be so small, it would be like having a trailer there. So we've done as much as we could. We want to pull it back, as I said before, to make it safer. I love the water, but I don't like being that close to the water. So we're pulling it back. A lot of the square footage in terms of the increase, we are extending it a little bit going towards the road, but we're also putting the 3rd floor on, and I think that's where a lot of the difference in the square footage comes into. I hope you can give us the approval. We're looking forward to proceeding on it. Any questions I can answer for you?
Any questions for this gentleman? No? No, we're all set? Okay.
Thank you.
Thank you, sir. Anyone else speaking in favor? Is there anyone here opposed to this application? Okay, this hearing's closed. So what do you think? Do you think we have enough here? Do you think you could, if you want
Well,
to
Joe,
pick and choose
I
some
mean,
of
I
the
think
variances?
that, I got to
think?
tell you, I think they did a really good job taking our advice, taking the deck off the front. I mean, it's a 16-foot wide house. It's basically a rectangle. They've got a very small deck in the back, and you can't do much more with this. I mean, 16 feet, very narrow house, and I think they did a good job.
Okay, any other comments?
What's the length of the house, though? I mean, they've added 10 feet onto...
57 feet, which isn't bad. I mean, they took a lot off this. They took the overhangs off, they took the side deck off. You got nice, you can walk around both sides of the house. I think they did a real good job.
I do agree that they made concessions, and they certainly made a concerted effort to listen to what we had to say. I guess my question is, did it go far enough? And that's just for the discussion among the board, because they are adding 10 feet more than they had before.
Yeah,
And
but John, look at that staircase. That staircase is taking up a lot of interior space. You can't, you know, and the bedrooms aren't overly big or anything. I mean, the front one there is only 13 feet.
all right, so another way, I put it out for discussion, because that's where the phase that we're in right now. Another way that they can reduce lot coverage, I believe, unless I'm misinterpreting, is they have the existing driveway that is the width of basically their entire property. And I think that counts as lot coverage. Is that correct? Where the driveway is, that counts as lot coverage, right?
Yes, driveways count as lot coverage.
Right. So I'm putting it out there as a possibility that one way that we could gain space, not eat into the house, but one way that we could gain lot coverage percentage is to remove the driveway on that strip where it does not drive directly into the garage. And that moves us closer, potentially, to our lot coverage not needing a variance.
Because you're looking at the percentage.
I am. I mean, I personally do not have a problem with the width of the house. I agree with, they've done a good job with that. I'm not in love with the length of the house, but there's more than one way to skin the cat of the lot coverage. So those are my comments.
Any other comments?
Well, if you took the asphalt out, they could put gravel and still use it for parking. I mean, if that's what we got to do to give them this plan, I don't have a problem with that, John.
What do you think? Sarah?
No, I agree. I don't have a problem with the width of the house. I don't have a problem with the length of the house. It's a very small lot. It's undersized. I don't have a problem with the side yard, the side variance requests, but lot coverage has always been an issue for me. And if there are ways to decrease it, I think we should explore that.
Mr. Harris, if that's a possibility, would that be a condition?
If the board is inclined to, if the board approves this project with a condition that goes something like lot coverage cannot exceed 65%, you need to have something to vote on. You have to be looking at something. How do we get from 79.9 to 65%? What gets taken away? You need something to look at. You need something to attach your approvals to. So as we all know, approvals are based upon everything that's submitted.
Well, Stephen,
So
if we
there's
put
nothing
something in there,
submitted that says 65%, you're really not voting on it. You're voting on an idea and not a plan.
what if
Okay,
we put a
so-
condition to replace the asphalt with gravel?
But does that reduce it to 65%, or does it reduce it to 52%, or does it reduce it to 69.2%? The board needs something to, the board has to vote on a plan, not an idea.
Well, the front driveway's basically 25 by 36, so that's almost
The
1,000.
math has to be done. You have to vote on something concrete. Bad metaphor, but you have to vote on something real, not an idea. Mr. Chairman.
I can't say-
Mr. Chairman, can I
Yes.
take time out for a second? Mr. Chairman, if the board is inclined to approve this, you can approve all of the variances except the lot coverage with the condition that the applicant present a revised site plan to the Planning and Zoning Office for review. And if that revised site plan indicates or shows demonstrably that lot coverage is no greater than 65%, we can go with that kind of a condition. So,
Okay.
just to repeat, the board can approve this application but deny the lot coverage variance and attach a condition that prior to a zoning permit being issued, lot coverage shall be no more than 65%. And
Okay, thank you.
that'll be demonstrated on a revised
All
site
right.
plan.
Good recommendation. Okay, so, we'll, you listen to that? Yeah, we're ready for a motion. Go ahead.
All right, let me try to get this right. I make a motion to approve with the condition that prior to the issuance of the zoning permit, the applicant gives us 65% lot coverage
The applicant
for the
must,
permit.
the applicant must submit a
Must
revised
submit
site
a
plan.
revised site plan for 65,
demonstrating-
demonstrate 65% lot coverage.
Correct.
We have a motion. We need a second.
Second.
We have a motion to approve with said conditions. And we have a second on the motion. Ms. Valaquit? No, just with the motion.
With the motion.
Mr. Soda?
With the motion.
Mr. Vecino?
With the motion.
Ms. Ferranti?
With the motion.
I'm with the motion. Approval with conditions.
Okay, item number 5. Okay. Item number 5, 16-point Lookout East, MBP 28/581/19, in an R12.5 zone. Thomas Lynch Esquire for Linda Fogler, owner. Variance of section 3.1.4.1, side yard setback to 5.7 feet where 10 is required to construct addition to a single-family dwelling.
Attorney Lynch, before we begin,
Yes.
I've been by there a couple of times. There was never a placard displayed. So if you can tell us how the neighbors would know that this is even coming about, then I certainly do not want to, put off this hearing. We'd like to hear this hearing, but there was never a placard. How were they notified?
Well, my client would be happy to come to the microphone. She picked the placard up from my office and taped it onto the house, so I'm not aware of that it was removed, but in the yard, okay, on a stake. She posted it on a stake in the yard.
I was by there last Thursday. I went by there today. It wasn't up.
Well, it was put up for the first, keep in mind that the hearing was postponed last month because of the storm, so that it was there for the first.
Oh, it was there
hearing.
last month?
Yes,
Okay, so it was there last month?
yes.
Okay,
Okay.
all right. So between now and then, it disappeared. So it was posted, so, okay. All right, proceed. Thank you.
Thank you. And just for the record, good evening. My name is Thomas Lynch. I'm an attorney with the law firm of Lynch, Trimbicki, and Boynton. My office is located here at 63 Cherry Street. And I actually have the pleasure tonight of being with a friend of mine, someone who's been a neighbor and a St. Mary's classmate going back many, many years, Linda Fogler. Linda is a lifelong resident of Milford. She's also an attorney who's practiced here in Milford for over 30 years. And last year, Linda purchased the property at 16-Point Lookout. It was a situation where there was a family that had owned the property for a good number of years. It had been in an estate and a trust, and she was able to purchase it in May of last year, and now wishes to make renovations to the house. As we all know with Point Lookout, driving through the neighborhood, it's a beautiful neighborhood, one of really the shining stars in Milford, and there's a lot of construction and renovation going on Point Lookout. Linda's brother Stephen and his wife Liz recently purchased another house on the other side of Point Lookout on the Sunset side, and Steve and Liz are actually have removed the existing house and are building a very large house on that lot on the other side of the, the neighborhood. So Point Lookout was developed back in the 30s and 40s. The house at 16 Point Lookout was constructed in 1948. It consists of some 1,500 square feet. It's actually a very small house. It's a 2-bedroom house with a total of 6 rooms in the house. And what Linda wants to do, and you've seen it on the plans that we've submitted, John Whitko, our architect here in Milford, has worked with Linda to design a reconfiguration of the layout of the interior of the house. There's going to be an expansion to the rear of the kitchen in the eat-in area. There's also going to be the elimination of a sunroom that's existing now, and then moving out into a patio with a grill area to the rear. There's also a portion on the easterly side of the structure with the addition that we envision to have a patio with a deck above it, with a 3rd bedroom then built on a 2nd floor addition over that particular area of the house. But you know, it's a total addition of approximately 1,000 square feet on a 1,500 square foot house. So it's going to, you know, keep the house relatively small, but it'll enable Linda to make the renovations that she does want to have. The variance that we've requested is on the easterly side of the property. That's where the garage is going to be slightly expanded. It's a very narrow 20-foot garage right now. So with the addition of the structure going back to the rear, it'll include an expansion of the garage on that side, and that's where we're asking for the variance. The R12-5 zone setback is supposed to be shown on here. It's 10 feet. We're requesting a setback of 5.7 feet. With the addition of the calculation of the residence, the Shea residence that's next door, that residence is some 15 feet off of the side yard, so that the combination of the 15 feet on the Shea property plus the 5.7 feet that would remain with the addition would create a total of 20 feet. So if each house on each lot were 10 feet and conforming with the side yard, it would have the same distance between the 2 houses. I think it's also noteworthy, and that's the claim that we're presenting to you tonight for a hardship, is that this is a pie-shaped lot. So if you looked at the site plan, it shows that the lot itself is wider in the rear, and it tapers down as you reach the frontage on Point Lookout, and that really creates a situation where the hardship exists because of the narrow configuration of the lot. But other than that, Linda's excited to get started on renovating the house. It's a fairly minor request that we're bringing to you tonight, and in terms of the reasonableness of it, we'd ask that you grant the application.
Okay, and looking at this, the house, proposed house, it fits in the property very well. Can you tell us the size of the garage and the extension by this picture? Is that a door next to the garage? Because that's this little piece here.
To the right side there, Joe? Yes, that's a door that would go through a...
So that, I mean, the size of the garage and that one little door over there, that's creating the variance. Other than that, everything else fits in there fine. So
Right.
what's the size of the garage? Do we know?
Right now, the size is 20 feet. It's going to then go to some 23, 24 feet. 25 and a quarter, sorry.
Okay, any questions for Attorney Lynch? No? Anyone else speaking in favor?
You know, I do, Joe, have a email that was sent to me from Judy and John DeFranco. They're the owners of the property next door to
Okay.
the left.
Yep.
I'd like to submit
Sure.
that. Obviously,
This
it's
is the house.
obviously it's an email in
This
favor
is the
of
house to the
application.
left.
Correct.
Okay, asked anyone, do you have questions for Attorney Lynch? Go ahead.
The house looks very nice, but the reason why it's encroaching on the setback is the extension of the garage. Was there any substantive thought towards altering that and then avoiding the
Well, that
request at all?
That whole line goes across the back of the property, so it's going to be the garage and then an area behind the garage, John. So that's going to be part of the expansion in the kitchen eat-in area as well.
So you're saying that the encroachment area, which is a rather small triangle, for lack, or maybe it's a trapezoid, but for lack of a better word, it's a small geographical area, and some of that geographical area is not the garage?
A small portion of it, most of it is the garage, but what I'm saying is to follow the line of the house straight back, you'd have to have a jog in if you were going to eliminate the area that was encroaching on the side yard.
Or you could just go straight back with where that new patio with deck above is, and you not make that jut out.
But that would actually make the garage smaller than it is now. And
That's not how it looks to me. From the shaded area is the new thing that you're putting in, right?
Correct.
So are you saying that the garage currently is not on the far left side of the house?
No, the garage is on the far right side of the garage.
Right.
Right.
Let's go with my other right,
so-
the right side.
Right, so what I'm saying is, a portion of this is going to be the kitchen galley and the pantry area. A small portion of this, you see the width dimension is some 5.9 feet coming out, and then it jogs out. I would say probably 3 feet of that, 4 feet of that is the actual expansion of the garage area.
So here's the 10-foot.
I think Bill said it was
Here's
25,
the 10-foot line,
25
so
and a
it is
quarter
just
feet.
this corner.
I'm just looking for a way that we could avoid the setback. But
John, if you, you're not gonna get two cars in a 20-foot garage. It's very, very tight. I mean, it's gonna be very tight. You wouldn't even be able to open the doors.
It's
So
extremely
he added that, and then he put the little jog in to try to make the setback a little bit less. So I think he did a pretty good job on it.
And these plans were drawn by John Whitco, so he does do a good job. And he tried to maximize as much as he could without like going up or going any further back as well.
of course, I mean no disrespect to the architect, I'm just merely questioning.
Any other questions for Attorney Lynch? Anyone else speaking in favor? Anyone speaking in favor? Is there anyone here against this application? No further questions? Okay, this is closed. This hearing is closed.
Thank you.
Okay. Mr. Soto seems to think we did a very good job here.
Well, you know, it's a pie-shaped lot, so you kind of, it makes it hard to square up a house when you got a pie-shaped lot, you know? When you don't have those straight lines.
Ms. Ferranti, do you have any comments?
I mean, I do agree with that. Most of the time, you see the lot lines going straight back from the street, and it's causing narrowness right at the front, which is where the problem is. You don't see the problem further back. There is no problem further back.
Okay, so we need a motion.
I make a motion to approve.
Second.
Approval is based on the hardship of the pie-shaped lot.
We have a motion to approve. We have a second on the motion. Ms. Ferranti,
With the motion.
Mr. Facino,
I'm against the motion.
Mr. Soto,
I'm with the motion.
Mr. Valaquit?
I'm with the motion.
I'm with the motion. It's approved.
Okay. Item number 6, 78 North Rutland Road, MBP 85/925/9A, in an R30 zone. Chelsea and Logan Casey, owners, variance of section 3.1.4, west side yard setback to 15 feet where 20 is required, to construct a 2-story addition. 4.1.4, front yard projection to 22.5 feet where 46 is permitted. West side yard eave to 14.5 feet where 16 is permitted. All of this to modify a single-family dwelling.
Good evening, Mr. Chairman and members of the board. My name is
Can you lift that microphone up just a little, please?
Not a
Thank
problem.
you, and start over again if you would.
Good evening, Mr. Chairman and members of the board. My name is Logan Casey. I'm here with my wife tonight to ask for this variance at 78 North Rutland. We purchased this property almost a year ago. It's a dilapidated property. And we are asking for a variance based on the hardship that, based on the trapezoid shaped of the property itself, anything that we are to do to the house is going to be in violation of the current setbacks. The house was built in 1949 and positioned on the property where it is so the rear could be used as a leaching field. We have made the necessary improvements to connect it to the city sewer. But again, where the house sits, anything that we do is, within those required setbacks. So we want to make our kitchen slightly bigger out the rear of the house, and then put a approximately 8-foot covered porch on the front of the house. As you can see, we're the last house on the street. It's a dead end. There's no cul-de-sac in front of the house. It just kind of ends in front of the house. It's really a one-lane road right in front of us. The neighbors we have talked to, and they are just happy that somebody's going to do something with the property. So we're here to ask for the variance tonight based on, again, the shape of the property itself, that anything we do is going to need a variance.
Okay, and in looking at this, this house in the outside lines, it is extremely sideways here.
Yeah,
So you're going to be rebuilding the same?
No.
You're taking the house down?
No. We're first-time home buyers, just doing it on a budget. Jim Deno, our architect, actually lived here as a child and helped us design the house, obviously. So where it is positioned, we are just going to extend the kitchen out the rear, I believe it's like 6 feet, and then add a covered porch just to the front of the house. So the 46-foot required setback of today would be right in the middle of our house. So we're asking to move that to 22 feet. But the existing house is staying. We are just taking off the second level and essentially putting on a new second level with dormers on it, because it was a small cape before. We're going from 1,300 square feet to approximately 2,200 square feet.
I'm sorry, can you give me that number again, please?
We're going from 1,336 square feet with the garage, there's a 3-car garage on the other side of the house, to approximately 2,200. So we're adding 864 square feet just of living space.
That's because you're doing second floor, right?
Yeah, we're just a second floor.
Okay.
Yeah. Yep.
Okay. Mr. Harris, he's stating that there's a lot of things he's limited, he needs variances for all these. Looking at this, is that true?
Whether an applicant needs variances, well, he's asking for variances. Are you asking me, should he get them?
I'm asking if you should get him. He's saying, he keeps stating that he can't, it seems like there's a lot of property over there, if you went by and looked at. He's stating that there's a lot of things he can't do unless he has the variances. So, I mean, in you looking at this,
It's up to the board to decide what people can do without a variance. or if a variance is warranted or not. That's not what I do.
My question to you was that he's saying he can't do any of these without a variance, so.
It's up to the board to determine if the statement is accurate.
Okay, thank you. Okay.
Well,
All right, John, go ahead.
Can I ask?
Sure.
Maybe I can ask this question. Stephen, let me know your thoughts on this. If he just raised the house, if he didn't do anything else but just went up, would he need a variance for that?
Departmental policy is that non-conforming structures can be vertically elevated.
There you go. So then by extending, right, that's why we're here, because he's extending the first floor level. So I think he could increase the square footage of his house by merely going up and staying within the existing footprint.
Any other questions? Anyone else speaking in favor of this application? Is there anyone here opposed? Anyone here opposed? Okay, so we had a few comments from Mr. Vicino. Any other questions?
I have a question. You had referenced that at one point, I believe it was in the 40s, that your setback would be in the middle of your house. Can you just repeat that?
So I was told that the required setback today is 46 feet from the front, from the road. And we're with the deck and everything, we would be about 22 and a half feet from the street.
See this dotted blue line right there? That's the setback line.
And it is a dead end. There's no other, we only have one neighbor, and around us is all deeded open land. There's
For
power
those who-
lines behind us.
For those who have a survey, what zone are they in?
They're in an R30, sir.
R30.
Okay, the front yard setback for the R30 is 50 feet, not 46.
Okay. If you're familiar with the old Milford Bowhunters property, that's all, it's all behind our house. It's all,
There's nothing else?
there's nothing there. There's high tension power lines back there, and then behind that.
So there's no way to build behind you or to the side of you from that point on?
No, and so where the house is positioned, I mean, unless we were to knock it down and build on the other side of the garage, but we would have to remove what is existing, and that's just not in our budget.
There's a three-car garage there. Was there ever a variance for that, or?
That was how
fit?
we purchased it,
Okay,
yeah.
okay.
That's in the setback.
Yeah, how it is now is we purchased it, you know, like I said, 12 months ago, just dilapidated, really falling apart.
But these porches, the porches in the front and on the side, those are proposed. There's no
The
existing.
porch on the side is already there. It's the only one, the porch on the front is that we're asking the variance for. Yeah, it's peculiarly, it's funky positioned on the property to be close to the road.
So the side porch is already there.
Yeah.
And the house is already there. The only thing you're bumping out is the back, and you're putting the porch on the front, which is what you need the variance
Correct.
for. Okay.
Okay. Any other questions? We're all set? We're all set? This hearing's closed. Okay. Okay, now we can have our discussion. What do you think? You're in favor? You're not
Well,
in favor? Is there any?
You know, they're putting a nice second floor on. They want a nice farmer's porch on it. You know, it's an old farmhouse, and it's way out there. I don't see a problem with it. The house was put diagonal on the lot almost, you know what I mean?
Okay, we need a motion. Any other comments? Any other thoughts?
What are we saying is the hardship, the position of the house on the lot?
I would say the position of the house on the lot.
Okay, thanks.
We need a motion.
I make a motion to approve.
Second.
Approval is based on the hardship of how the house is positioned almost diagonally on the lot.
For motion to approve, we have a second on the motion. Ms. Falcat?
I approve.
With the motion?
With the
Just say
motion.
with the motion.
With the motion.
Okay, thank you. Mr. Soda?
With the motion.
Mr. Facino?
With the motion.
Okay.
Ms. Ferranti?
With the motion.
I'm with the motion, it's approved.
Okay, item number 7, 88 Bray Avenue, MBP 15/43/13 in an R10 zone. Linda Testoni, owner, variance of section 3.1.4.1, front yard setback to 17 feet where 25 required. Section 4.1.4, projection to 6.2 feet where 21 feet permitted to construct addition and fireplace on a single-family dwelling.
Yes, good evening, Chairman and
You're gonna have to lower the microphone, thank you.
Okay, sorry. Good
Thank you.
evening, Chairman and the board. I'm asking to put a fireplace in my living room.
We need your name and your address for the record, please.
Okay, my name is Linda Testone. I'm the owner of 88 Bray Avenue. I've been there for 32 years. And I'm asking for a variance to put a fireplace on to the left side of the house that will bump out. It's going to be a gas fireplace, vented. And I'm also asking for a room, an art room, I'm calling it now, to be converted to a bedroom to age in place. That's going to be off on the right side of the house, and then a 2-car garage. And I had submitted plans to show you the elevations also.
Okay, so we need a variance on the front corner for a fireplace.
Yes, the air conditioner is there right now. We're just going to spin the air conditioner and put the fireplace there.
On the other side of the property, is it mostly for the garage?
It's going to be, the room is going to be attached to, that's where my side door is in the house. So I'm going to have it going into that art room slash bedroom, future bedroom. It'll be 13 feet by 12, 6, I believe it is. 12.4. And there's going to be a 4-foot, 6-inch deck off the front of that room, a covered deck for the entry to the house. And then the garage is 28 feet wide by 26 feet deep.
Okay, so can I ask you a question?
Yes,
The proposed garage,
yes.
it's even on the back. Can that be moved back? Because it's 17 feet right now, is what you're asking for, but you do have plenty of property behind the garage. Is there any reason that can't be moved back to eliminate that variance?
To get in, how I was looking at it is when you come out the side door, right on the side, the door to the garage, I need room to come out into the garage. That's why we're moving it forward. And the other thing is, my neighbor is directly right on the property line in the back, and I don't want to be a hardship too close to him. It's an old neighborhood. It has, they were, I guess, cottages at one point, and he's like 4 inches on one side and about 8 inches from my property line in the back. His name is Rose.
So how much property is there behind the garage to the property line? Do you know in feet? I'm trying to figure it out here.
I didn't figure that out.
About 30 more feet. For the setback to the rear.
There's a huge tree back there. I don't know. I was thinking, when when you come out, can I approach to show you where that door will be to go into the garage?
Yes, you can come here. You're going to have to talk into my microphone.
Sure.
But you certainly can come up here. Okay, so just speak into this.
Sure, I'm not sure if Nino put it on. This is where the door is into my house,
Right.
the side, right there. So I was going to have another door right here to go into the garage with a landing. So when I open the door, I have stable footing before I go down
Okay.
into the garage.
So what I was saying to you is if this was pulled back, then you wouldn't be able to get into the garage that way.
No, not coming,
Because
not
this
from
looks like
here.
this is the start of the apron for the garage here.
That is where the garage will be. This is where my setback is.
Yeah.
Nino said that this is where it is. My house is very close to the street, always has been. So I'm just asking for 8 feet just to pull the garage so that the stairs are even
Okay.
with this. From what I understand from Nino, they don't like when stairs come out past the garage.
Who's Nino? Is he your builder?
The surveyor.
Okay.
Yeah, I call him Nino.
Okay.
Yeah, he's done the surveys on my house right along. So,
Okay, we're just trying to figure out
Okay.
why, you know, if there was a possibility to push it back, then, you know, that would,
it's a gravel driveway right now, and it's 3 cars wide.
because to be quite honest with you, I mean, this site over here for a fireplace is really, that's minimal on what you're
Right.
asking for. But
Yeah, I was just gonna add on a room to
Okay.
age in
any
place.
questions while this lady's here with us?
Well, is that?
The
There
garage
is no
There
garage.
is no garage
I'm going to
proposed.
add it, and actually, the closet goes into the garage from this room. When it ends, I was gonna put the closet bumped into the garage and have the landing here to step out on. So I have at least room in that room.
Okay.
So that,
Okay.
you don't have the other plan?
I do.
No, I guess not.
Okay. All right, yeah, if you would go back there, then we can
Thank you.
finish up, please. Okay. Do we have any questions for
I do.
this lady? Go ahead, Jim.
All right, so this is a brand-new garage that you're trying to incorporate into the house.
Yes.
So have you ever discussed with your surveyor or with whoever is working on the plans on a set of plans that does not encroach on the setback for the front?
No, he asked me, Nino had asked me what I wanted to do. I'm a local artist, and I've been here for 32 years, and I was hoping to, I made the garage a little deeper so that I can store my art, my mailboxes. I paint mailboxes, birdhouses, and slate. So I actually didn't talk to him. I'm
Okay.
trying to think what aesthetically would look good, and that doorway is my main focus, to go right through.
Sure. That might be something that if you had more time and more opportunity to discuss it with them, that you might be able to come back with a plan that doesn't require that variance.
The way the stairs, I had projected the stairs are like the stairs in the front. When you come out that door, if you come out the house into the garage, I would exit to the right. If I move the garage back, that means I'm exiting to the back of the garage, which means if I get out, the way I thought where the cars were parked, it would be easier to come out and go this way into the garage. I mean, into the house, versus get out of the car, go to the front, go around to come in. Like if I were to flip the stairs the other way, that's what I was thinking. I drew the plans for that. I drew that CAD. So I was going for ease of getting out of a vehicle, getting into the house.
Any other questions for this lady? Any other questions? Anyone here speaking in favor of this application? Is there anyone here opposed? Okay, no further questions, this hearing's closed.
Thank you,
We'll have an answer for you shortly.
thank you.
Discussion? Go ahead, Mr. Vicino.
There might be an opportunity to give some additional time for the applicant to maybe revisit the plans and see if we can avoid the variance request with some professional eyes on it and some discussion about how they can make it a workable situation. That's my thoughts.
Okay, any others?
Well, here's the way I look at it. The existing house is 2.8 feet from the street. She's pushing the garage back 17 feet. She's got a large tree back there. I really don't have a problem with it, I mean. It's not like she's asking, she's moving it up to 2.8 feet, she's back 17 feet. You can still, you know, so it's a tough one without seeing all the conditions, you know?
Any other thoughts? Ms. Ferranti, what do you think?
I'm tending towards Mr. Soda's opinion, with the house being so close to the street. Right, the garage is kind of,
It is back.
it's almost a non-issue because the house is already so much, infringing so much more on the setback. And for the record, I don't have a problem with the other variance request for the fireplace.
Okay, any other thoughts? We need a motion?
I just want to say one other thing, you know, with the house being so far forward, you don't want the garage too far back, because then getting in and out of the existing house is going to pose a problem, you know what I mean? So,
I think that's exactly the point the
yeah,
applicant was getting
I
at.
think she can't go back much further, you know what I mean?
I make a motion to approve.
Second.
Motion to approve is based on the existing position of the house on the lot and the relative position of the addition to it.
We have a motion to approve, we have a second on the motion. Ms. Valcott?
I approve. Second. I approve with the motion.
With the motion.
With the motion.
You'll get it, you'll get it. First time.
I got it right.
Mr. Soda?
I'm with the motion.
Mr. Vicino?
I'm against the motion.
I know, really.
Ms. Ferranti?
I'm with the motion.
I'm with the motion, it passes.
That's okay. All right, item number 8. 32 Gulf View Court, MBP 37/588/5C in an R12.5 zone. Doron Munzer, owner, variance of section 3.1.4.1, side yard setback to 9.1 feet where 10 is required. Section 4.1.4, 4.1.4, front yard projection to 19.2 feet where 26 is permitted, and front porch projection 23.6 feet where 26 is permitted. 6.3.2, expand a nonconformity, all to construct a new single-family dwelling on an existing footprint with additions.
Hi, my name is Doran Munzer. I'm the owner of 32 Gulfview Court, and I'll try to be as brief as I could. I'll just give you a little background. I bought the house about 3 years ago, and I hired a different architect at the time, and I had plans developed, spent a lot of money, about 3,400 square foot. During that process, I developed an illness that put me in the hospital. I almost died 2 years ago. I bought the house June 30th, 2015, and 3 months later, I was battling a disease that in and out of the hospital for 6 months. I had 3 major surgeries, came out of it okay. I rented it, I put the project on hold. I rented it to tenants, came out of it, and then hired Dan Pato, my new architect, and I decided to reduce the size of the house and make it 2,800 square foot with a 3-bedroom, 2.5 bath. So my hardship is that the existing lot is a lot that is, oh, excuse me, what's the wording here? Yes, it's an irregular lot, and there's only 2 variances we're going for, which is a front porch, and if I can present you some pictures before I continue to show you the existing stoop and front porch, is that possible?
Yes, you can. You can bring it forward.
Show 'em. I think I have 7 copies of everything. I don't know, I hope that's enough. I hope you can read it and see it clearly. So,
Before you go forward,
yeah.
You're showing us a picture right now of your existing front porch.
It's the existing
You're planning
front-
on taking the house down,
Yes.
correct?
I am.
So this porch is really not going to be a factor at all?
Well, the reason why I presented that to you is because that porch is already out of the variance. In other words, no matter what I do, in order for me to tear down the existing house, I'm keeping the existing foundation, which is a basement. I got a full basement. It's totally out of the FEMA line. The setbacks on where the garage is should be 10 feet, and I have it at 9 feet 1, so I'm looking for an 11-inch variance on that. But the main thing is the front porch. The treads on the front porch are 12 inches wide, and I have lymphedema of my left leg. I have trouble walking. I'm putting a master bedroom on the first floor. This is my house. I'm retiring in this house. This is my dream home to live on the water. So right now, just walking up the existing stoop and treads on that, they're 12-inch treads. I wear 12.5 size shoes, so for me to even walk up, I can't even walk up straight on the existing tread. I have to go on an angle kind of to get up the, oh, I'm sorry, to get up the.
So what you're saying, though,
and we're going
this front porch, this front landing,
yeah,
that exists on this house.
The stoop,
yes. It is already in the, it's already, it exists as a variance. Does it, Mr. Harris?
It exists, yeah.
What was the question again?
He showed us a picture of the existing house with the front landing. We're wondering if that is already there with the house that's there, if that variance already exists. Or he's creating the variance right now by how they're proposing the house.
The new front porch and stairs are bigger than what currently exists, so that's why he needs the variance for that.
In other words,
he can build over the existing footprint of the house, which he's doing, and he's adding on to the house. Most of what he's adding on conforms. There's a little bit in the front yard that does not conform. So it's that little bit in the front of the house and the new porch and stairs that he needs the variance for. That's what he's asking for.
Okay, okay. So what you're saying, of course, which is making the front landing larger, is that they're only 12 inches.
Yeah, the treads right now are 12 inches. We're making it 14 inches so that you can comfortably walk up the stairs. I think most people on a 12-inch tread, it's very small. I can barely walk up there. I have to angle my shoes to get up to the front steps right now. They're 12 inches each tread. There's 2 treads, and then there's the landing. So we're just building it out. 14 treads, making the porch a little, in fact, I'm going to give the technical details to Dan, because he's my architect. In fact, you want to take over? I think, but the hardship is that you know, I need to produce larger treads. I just can't walk up the existing steps
Okay, so it's
right
going to
now.
be, yeah, it's going to be 19.2. Okay.
So, Dan,
All
why
right.
don't you take over?
So you're speaking in favor, sir? If you are, please give your name and your address, please.
Yep. Good evening. I'm architect Daniel Pato. I have an office in Stratford, Connecticut, 128 York Street. I just wanted to talk, so basically we're seeking the two variances, one for the side yard setback and one for the front yard, front porch. The allowable building area of the irregular lot is formed by the FEMA flood line and the building setbacks. And this severely kind of constricts our buildable area that we have, and it seriously impacts what my client is able to build there. With regard to the side yard setback, basically we're seeking to follow the existing footprint of the existing garage, and are trying to basically stay within the footprint of the existing garage. But we're also extending the front of the garage forward to obtain just a moderate amount of storage at the rear of the garage. The current garage actually protrudes over the side yard setback about 10 3/4 inches, or actually it's 0.9 feet, or about 10 3/4 inches into the side yard setback. Our proposed addition pulls the garage forward about 4.5 feet until it crosses back over the side yard setback into the back into the buildable area. This forms a small rectangular sliver that is about 10 3/4 inches by 4.5 feet, or about really only about like 24 inches of square inches. But what we're also doing is we're pulling the entire garage forward a bit, and this actually reduces the current nonconformity. If you'll see on the survey, there's a little triangle at the back corner of the garage that's about 5.3 feet long and about 1.5 feet wide. By pulling the garage forward, that rectangle, which is about 8 square feet, that nonconformity is reduced, because that sliver that we have that is nonconforming at the front of the garage is only about 2 square feet. So we've actually reduced that nonconformity by 6 square feet. And then with regard to the front porch, at the front of the house, we're proposing a covered front porch that protrudes into the front yard setback. The front porch would replace the existing front porch, which is in severe need of repair. But obviously, whatever we do at the front of the house, whatever we propose, we're going to be in violation of the front yard setback, because that 30-foot setback goes right up to the front of the house. So whatever we do, we're going into that front yard setback. Yeah, and the existing stoop is actually non-conforming as well. The existing stoop is 7'8" wide by 6'3" deep. So we would like to replace this damaged porch with a covered porch that will be 20 feet wide and 6'6" deep, with steps that will take you down to grade. We believe that this is like a modest-sized covered front porch, and that will add some charm and curb appeal to the property. My client also has full support of his surrounding neighbors. That's about it.
I don't have writing, but verbally everyone.
Okay, thank you. Thank you. Anyone else speaking in favor? Anyone here opposed? If you're opposed, please come forward. Okay, yeah, if you want, just briefly.
say, well, I do, but...
Go ahead, I'm sorry, go ahead, sir.
Oh, I'm sorry, my name is Frank Bonish.
You have to speak into the microphone, please, Frank.
Sorry. My name is Frank Bonish. I live at 22 Gulfview Court. I'm going to be his neighbor. He's moved in right next to us. I've been there for 26 years, 28 years. And the only thing I object to, and I can't do, there's nothing I can do about it. My view of the Long Island Sound is going to be covered by the extension that he's going to put on the back of his house. But there's nothing, he's legal and it's all right. The only concern I have is it's an old house, it's going to be demolished, and I know there's asbestos in that house because my house had it, and I had to take care of it. And I know there's lead paint in that house, and I just wonder, is there any kind of rules that the construction guy has to make sure that that dust does not get into the neighborhood? Because we got a lot of kids.
There has to be a full environmental survey done on that house before they demo it.
Who's talking?
I am.
Oh,
They
sorry.
have to do an environmental survey. They go in, they sample everything, and then the guys come in and remove the asbestos and everything legally before the house can be demoed.
Okay,
That's standard
because
procedure.
I have a COPD. And,
No, they take care of,
they take.
it's all
okay.
done
well, that's
legally.
all I have.
yeah.
That's all I have to say then.
All right, so you're not in opposition?
I'm not. I can't. No, I'm not. It's going to be a beautiful house.
Okay.
So I wish I could build it.
Well, you know, you have the right to ask those questions. It's something that this board would not be considering because we're just looking at the variance to build this house. So.
Yeah,
Okay, thank you. Thank you.
Yeah, we had even had a party. We invited Darren. It's a very, very nice street to live on. They were all very friendly people, and they invited Darren to the party, and so he got to know the people already.
Thank you. Okay. Any other questions? We like our neighbors now, so that's good. So. There we go. Okay. All right. So this hearing's closed. Okay. Hearing's closed. We need a motion on this.
Are we going to discuss it?
We need some discussion.
Well, basically, he's putting a 6-foot front porch with a few steps on there, basically what he needs. I mean, 6 foot isn't over exceeding what I think he needs. And the little front jog out on the garage, it's almost on the property line anyway, maybe 6 inches is hanging over. So there's very little here. I think they did a good job.
I agree.
Okay, who wants to make a motion? John?
I make a motion to approve.
Second.
Motion to approve? Reasons?
Approval is based on the hardship of the lot being a cul-de-sac and the house not sitting parallel on the lot.
Okay, we have a motion to approve. Did we have, who made the second?
I did.
Okay, we have a second. Ms. Valaquit,
I'm with the motion.
Mr. Soder,
I'm with the motion.
Mr. Vecino,
I'm with the motion.
Ms. Ferranti.
With the motion.
I'm with the motion, it's approved. Okay. New business? Okay, we have some new business. Under new business, consideration of appeal of a Superior Court decision, Turk versus Zoning Board of Appeals, City of Milford.
I could have read that for you, sir.
This is, oh, I'm sorry. Well, you're reading over.
Mr.
I didn't
Chairman,
fire.
if I could,
Mr.
if I could
Mr.
refresh
Harris.
everybody's memory.
Mr. Harris, you want to speak to us on this?
He's waiting.
Yes, just to refresh your memory, 59 Hillside had a storm-damaged house and a storm-damaged accessory building, and the plan was to demolish the accessory building in the house and build a new house. And the applicant asked for several variances. They were reducing lot coverage and building area because they're getting rid of the accessory structure, and they're asking for some side yard variances and height variance. And the board denied the application because you didn't find hardship for the height variance. The property owner appealed your decision to Superior Court, and the decision came down in favor of the homeowner. So in discussions with the city attorney's office, we are asking you if you would be inclined to take an appeal to the appellate court.
Okay, thank you. Okay, I'm going to recommend an appeal as to not override the city zoning regulations. We know that the city height regulation is 35 feet. The judge ruled 39 and a half, so that won't be acceptable to us, so we want to appeal that decision. This was only set a new precedent around here, you know. We've been kind of sticking to the 35 as the zoning regulations state, so we need a vote on this, so we can vote on it. We need a motion to vote on this.
I have a question. Is the decision in the P&Z office so we can come read it?
It should be in the file.
I can, no, do I have it? I know I made copies.
I don't know if you do have it, or it's just, it
I
was
don't
passed down
have
to
it
you
on me.
because...
I'm pretty sure I emailed it to everyone, but I don't believe, no, I'm
It
sorry.
should be in the, oh, we don't have the file. Do we have?
We
you
don't
know?
have a 59.
We can run across the street, make copies, and take a recess to give everybody a chance to read it. It's 31 pages long or so.
I don't think that's necessary.
It was really out of my own curiosity. I mean, I don't actually need it right now, but I want to know that it's available.
Oh, it's available. I'd be happy to email it to everybody.
Stephen, just as a clarification, did you say that the city attorney was recommending bringing suit in the appellate court?
No, the city attorney recommended that the board vote on it. Speaking just for myself, well, I'm not going to speak for myself, but that's, the city attorney would like the board to vote to see if they want to appeal this to the appellate court.
We have a question. Go ahead, Mr.
Yeah, has the city attorney indicated the likelihood of success on appeal?
Well, anytime you go to court, you'd like to think you're going to win. That's not always the case, though.
I think we should move forward on the recommendation for the city attorney as to not change our zoning regulations the way they're stated. So we need a motion to, if you all agree, we need a motion to appeal the decision of the judge that ruled on this case. And the case was Turk versus Zoning Board of Appeals.
I make a motion to appeal to the appellate court the Superior Court decision of Turek versus Zoning Board of Appeals for the City of Milford.
Technically, it's filed for certification, but that's fine.
Okay.
I second.
We have a motion to appeal the judge's decision, and we have a second on the motion. Ms. Valcott?
I'm with the motion.
Mr. Soda?
With the motion.
Mr. Vecino?
With the motion.
Ms. Ferranti?
With the motion.
I'm with the motion. Okay, what's next? Let's see here. New business. Old business? Any old business? Egg only has one job now. Is that old business?
No, actually, that's the staff update.
Staff
I have
update.
a wonderful new colleague, Susan LaFond, who has made my life much, much more pleasant.
Okay, thank you. Acceptance of the minutes, February 13th. Who read the minutes that were, are we all set with the minutes?
Way back when?
February 13th was our last meeting. We need a motion to accept the minutes from
I
February
make a
13th.
motion to accept the minutes.
Second? I'll second. Okay. All in favor? Aye.
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 Opposed? Okay. Minutes carry. Applications for next month.
One came in
Meg says
today.
one.
So we might have a short meeting, so we can discuss 40 Crabtree again, so. And it's just a vote. It's, the hearing's closed, so it's just a vote. Okay. Motion to adjourn?
Second.
This meeting is adjourned.